There we go. Now we're recording, so now we're in good shape. So once again, my name is Neil Kalin. I'm joined by Michael Simkin from the Real Property Law section, and our special guest interviewee is Ann Woodsum, who's going to tell us a little about her life, her law practice, things she does outside of the law, and also is going to contribute to part of our discussion. We've got 4 interesting cases that we're going to be discussing today. But before we do, here's what, before we do, we're going to just have a little Valentine's Day, just brief mention today, and then we're going to discuss Terry Walla versus Mack, Whitlatch versus Premier Valley. We've got our interview, then Frazier versus Superior Court, and there's really 2 cases that we're going to discuss at the same time. You see them, Shusha and Another Planet, about COVID-19 coverage, insurance coverage. So let's get us started here, where our last few are signing on. By the way, Michael, I think this is one of the highest registrations we've had since What's Up With Us started. And we know everybody who registers can't ultimately make it to the program. And Michael, you just started like 2 months ago. So maybe you are a factor here in having one of our highest ever registrations for What's Up With Us. So we'll have to see if that continues going forward.
It will, because you never know what type of guests I might bring on the show.
That's true. Michael does have a history of bringing very interesting people for us to interview. So just in light of yesterday's Valentine's Day, I thought, this being the day after, I would ask our audience, you don't really have to answer, but just something to think about. And are you in the doghouse? Are you in the penthouse today? Or are you just one of those which, you just don't care? Valentine's Day, you could take it, you could leave it. It doesn't mean anything to you. So just think about yesterday and think about where you are today. And hopefully you're in a good position, a good place to learn about what's up with real estate law. And with that, we're going to jump right in, unless Michael or Joanne wanted to comment about their Valentine's Day.
No comment.
No comment. Okay, so we're gonna move right along. We're gonna start off with Terry Walla versus Mack. This is a California appellate court case. Case involving, excuse me, a case involving easements and whether an easement stays or an easement go. So let's look at our fact pattern here. We have Mack, who acquired property in 1994, right? He acquired title to 2 adjacent properties. These properties were in the Mack family for years. They were changing title back and forth, but eventually eventually Mack acquired title to both of them. One of them had a small residence on it, kind of dilapidated, needed to be repaired. It was landlocked property. The only access to the road was over a neighboring property. The other one that Mack owned, the landlocked property had an easement over the neighboring property, which was vacant land. Okay, so when Mack acquired the dominant property, the one that had the right to the easement, what did Mack do? Well, he immediately encumbered it, at the time of its acquisition, and the deed of trust for the lender made reference to the easement over the vacant land. Mack wound up apparently refinanced a couple of times, and in both of the refinances, the deed of trust also mentioned the easement over the vacant land. Ultimately, Mack defaulted on the loan in 2011. The lender foreclosed at the property. The lender gave Mack some time to get out, to remove the belongings. The lender, it sounds like, was very generous at this time. Mack, not so much so. And eventually, 4 years after the foreclosure, the lender wound up filing an eviction to get Mack off of that landlocked parcel. The lender wound up selling the property post-foreclosure and sold it to Terry Walla. My favorite line for this entire case is this next one. Mack did not welcome his new neighbors. How true is that by looking at the case? He denied that the easement existed. He blocked access to the driveway. He placed garbage in front of the entrance, old appliances, decaying cars, and my favorite, somehow he moved an inoperable RV to block the entry to the easement. What a pleasure it must be living next to Mr. Mack. So Tariwala, of course, sued to enforce the easement. Mack kept his interference, was found in contempt of court twice during the course of the proceeding, but nothing seemed to bother Mr. Mack in his decision. The trial court ultimately held that the easement was valid and enforceable and issued a permanent injunction preventing Mack's interference. Mack wound up appealing that decision. That's the case we're talking about today. And he argued that the servient tenement, the easement, was extinguished by the doctrine of merger, since he held title to both properties at the same point in time. So what did the appellate court do? The appellate court looked at the case, looked at Civil Code 811, and looked at another Civil Code section as well, if you wind up reading the case. And that Civil Code said a servitude is extinguished by the vesting of the right to the servitude and the right to the servient tenement in the same person. Well, that's Mack's argument. He had title to both. So there's no reason for that easement to exist anymore. It was an unnecessary easement as soon as he acquired title to both of the properties at the same time. But there were some other issues here that the court thought were relevant. Since the landlocked property was encumbered, it was never held in what was called the same unity of title. Those of you who are probably a little closer to law school may know more about unity of title than I do. But what did the court say? That unity of title requires equal equality and right of possession. Well, there was no equality because Mack immediately upon acquiring the property in 1994 encumbered the property, and that encumbrance made reference to the easement, right? And what was the purpose of the easement? Well, of course, the lender who made the loan needed the easement because that helped establish the value to the property. Landlocked property has very little value in California and probably most other states, right? So that ensured that the lender would have, really marketable property in the event of the foreclosure. The court wound up saying a merger will not extinguish an easement if the result would be inequitable or result in an injustice, injury, or prejudice to a third person. And here, if the court did uphold merger, it would be a prejudice to certainly Tariwala, and by reference, really, in case there was not a transfer post foreclosure to the lender that made the loan that ultimately was being foreclosed on. Judgment for Tariwala was affirmed in this case. So you've got the issue of unity of title, you've got the issue of equity, right? So to me, certainly, I think the court had to be influenced by the terrible behavior of Mack and by a general principle, right? That the court's duty is to do justice. And I believe, an easement is an action in equity, and the court said it would be an inequitable to find for Mack in this situation. Michael, I know we were talking about this a little before, and you wanted to bring up another issue as well. What do you think about Tariwala versus Mack?
Like most cases, the facts matter. Like you mentioned, this servient tenant was beyond being a bad neighbor, okay? And that the court also looked at it even makes a reference there about granting security interest in one property but not the other, left open the possibility that the unified estate could be disjoined if he defaulted on the loan. So that's what you mentioned about unity of interest. And the loan issue is something that comes up. They didn't mention in this case, I guess it wasn't relevant, but a lot of people don't realize if you go to the bank and you get a loan and there's a deed of trust, the bank is giving you that loan on that property at that point in time. If you modify that property, then the lender is they're getting less of a security interest. One thing that I've seen happen is people make an easement. And I've had this case once where someone made a consensual written easement with his neighbor about using the driveway or whatever it was. And then the person that signed giving away that easement defaulted on his loan. The lender now became the owner of their property. And then when the neighbor said, well, I built this structure here, I'm using the driveway, they said, well, you can't, because the person that gave you the loan didn't have the right to give away part of the security interest. So that's another issue that does come up every so often.
Yeah, so in the case you just described, there would be a senior interest in the property, and the person who took the easement would be taking subject to that senior interest. And when the senior interest foreclosed, that it essentially wiped out the easement that was granted post loan, right?
Yeah, I'm just amazed in this case. This guy lost at every court hearing. He lost in the beginning with the preliminary injunction. He had no chance of winning, but he went through even with an appeal. And even the court publishing this, I don't see the new law here, or a clarification of the law. It seems pretty standard to me, but it's just crazy how people sometimes push.
So I have a quick question, Michael. In your example, what would the proper way have been? Would it have been to get the lender's consent to granting the easement?
Yes. Yeah,
okay.
You can do that.
Yep, that sounds right to me too. So I was giving a presentation to realtors recently, and I mentioned sort of a side issue with this case, which is, if Terry Walla wants to sell the property, does Terry Walla have to make a disclosure about Mac's conduct? And certainly if Mac's conduct continues, and he continues to defy even the Court of Appeal and the permanent injunction, that Terry Walla will have a disclosure issue and may in the future wind up having another claim against Mac for diminution in value of the property as a result of having to make a disclosure about this terrible neighbor. Anyway, so that's case number one. As you say, we got a full agenda today, so let's move on to case number two. And case number two is Whitlatch versus Premier Valley. And this is a case that was originally unpublished, but wound up getting published in mid-December last year. Now you see that little parenthetical up at the top of your screen, which is the losing party has filed a petition for review with the California Supreme Court. They just did that a couple of weeks ago. The Supreme Court has not yet made a decision about whether to grant or deny the petition for review. So let's see what's going on with Whitlatch versus Premier Valley. So Whitlatch is a real estate agent, filed a class action under the Private Attorney General Act against Premier and the franchisor, Century 21, alleging violation of wage and hour laws under the Labor Code, and for misclassifying him and others similarly situated as independent contractors rather than employees. So Whitlatch obviously had his license, real estate license, hanging with Premier. Premier demurred on grounds that, well, this claim doesn't matter. Whitlatch is an independent contractor. He's not an employee, so he has no right to bring a claim under the Labor Code that applies to employees. Whitlatch asserted, well, wait a minute, that independent contractor agreement was unconscionable. And because he was also a manager, so he was acting in two capacities. And my understanding is he had two different contracts with Premier. He was acting as a salesperson and as a manager. Said, well, since I was acting as a manager, I'm allowed to bring these claims in my capacity as a manager. Case went to trial. Whitlatch demurred, right? Or Premier demurred, excuse me. Premier demurred. The trial court sustained the demur. Said the applicable test for determining if someone is if a real estate licensee is an employee or is an independent contractor is found in the Labor Code. which brings in sections in the Business and Professions Code and the Unemployment Insurance Code. The Labor Code was created in 2019 when the California legislature adopted AB 5. And a lot of people are aware of AB 5. It was an attempt to make a lot of, so-called independent contractors into employees. It was targeting, right? It was in targeting some of the ride-sharing businesses and the like. So the court said, well, wait a minute, there's an exception in the labor code for real estate licensees, and therefore the trial court denied the Whitlatch claim. They sustained the demur. Whitlatch appealed. He argued before, and then he threw in another argument that labor code section, because it makes distinctions between different kind of persons, some would be deemed employees and some would be deemed independent contractors, that the labor code section itself was unconstitutional. The appellate court affirmed the dismissal, and I broke out some of the main causes of action that were addressed in the opinion. And the court looked at, the labor code, said, well, wait a minute, what do we have here? There's a presumption of employment using this ABC test established in the Dynamics case. I'm not sure of the pronunciation, from 2018, a very famous case that basically said, we're not going to use this control test from another case called Borrello. Instead, we're creating this new test, the ABC test, which essentially looks, at a few major factors. Is this person who's claiming to be an independent contractor in a role that is typically or traditionally seen as an independent contractor? Is there any control? And is the independent contractor's business different from that of the hirer? And of course, those tests really would not make much sense in the real estate licensing contest, because under law, the real estate broker has a duty to supervise the activities of a real estate salesperson. And a real estate broker and a real estate salesperson, of course, are engaged in the same line of business. So the ABC test really does not apply. The statute that was enacted in 2019 exempts out real estate licensees. And the court says, well, as long as the statute applies, then real estate licensees are not employees. And there's really a simple three-part test for making that determination. Is the agent licensed? Is the agent paid through commission? And does the agent have a contract stating that the agent is an independent contractor? All three of those tests were satisfied in the Whitlatch case. On the unconstitutional claim, the court said, just because there are some exemptions to a statute, that does not inherently make the statute unconstitutional as a violation of equal protection. And the legislature has grounds to do so when parties are not similarly situated. They dealt with the unconscionability issue very, abruptly. They just said the independent contractor agreement is not inherently unconscionable, and anything that is objectionable could have been severed. And for the sales manager claim, the court easily dismissed that as well. They said, in your capacity as a sales manager, you're not representative of the class of salespeople that you're trying to bring this claim on behalf of. So, the Whitlatch just lost on all four grounds easily. As a representative of the real estate industry myself, it's nice to see a case like this. The case was not originally published. The company I work for, California Association of Realtors, wrote a request to the court requesting publication. And you see the court agreed to do that and published in the middle of December. Michael or Joanne, any insights here?
I think realtors fall into A, B, and C. So I see what the court's thinking. It's pretty clear.
Yeah, it's really kind of amazing to me, the pre-existing statutes that were around for a long time. The Business and Profession Code and the Unemployment Insurance Code says right there since 1991. And there were, over the years, many challenges to that, but I never saw any of those challenges reach the level of a court of appeal until this Whitlatch case. And the Whitlatch case, of course, came after AB 5. So then there was this other statute that incorporated all the others. I think it made the claim much harder for Whitlatch to ultimately succeed on. And for the industry as a whole, where most real estate salespersons enjoy their status as being independent contractors, most do not want to be employees. Can they be an employee? Sure. If they agree to that with their broker, they can be an employee. But almost everyone in the industry finds the independent contractor relationship to be more favorable to both sides. And that would have been really undermined if Whitlatch was successful in his claim. All right, great. So let's move on. Joanne, we get to hear a little bit about you. Michael, I think you're going to lead the interview. So why don't we let Michael start off here?
Well, Joanne, you know, what I wanted to speak with you about is you're apparently heavily involved with something called California Women for Commercial Leasing, and you're even putting on a symposium. So we get a lot of people that see this show that are new lawyers or maybe even new to leasing, and commercial leasing is a different animal than residential leasing. So would this symposium be something that people should be looking into?
So the Women in Commercial Leasing, it's actually Women in Leasing Law, and it's a group I founded 9 years ago now. And every year I put on programming around commercial leasing. And the point of it in the beginning, and now we're so successful, we may be putting ourselves out of business, was that I went to the annual Real Property Law Conference, as it was then called, in, 12 years ago now. And I happened to notice that the vast majority of attendees were older white men, and the vast majority of the speakers on the panels were older white men. And in fact, less than 25% of the speakers on the panels were women. And so I wanted to figure out what was the pipeline problem. Why weren't, because at that point, you know, certainly we've got very good representation of women commercial leasing lawyers, my particular practice area, as well as women in real estate law. I mean, back in the day, it was very male dominated, but now there are a lot of women, but they weren't showing up at the conference and they weren't showing up as speakers. And so the point of the Women in Leasing Law was to help loosen up that pipeline, mentor women, commercial leasing lawyers, to encourage them to become speakers at these smaller programs. And men were always welcome to attend the programs, and we have had a lot of men attend over time who are allies for women in their firms, in the industry generally. And so over this period of time, through my efforts and the efforts of a lot of other people at the state level, now we are committed and are successful in having at least 50% of speakers at our programs be women. And that's why I said we might be putting ourselves out of business pretty soon. But we, for the first time this year, Women in Leasing Law is partnering with the California Real Property Law section for the annual retreat taking place March 24-25 in Sonoma, California. And what that means for my group is I'm organizing and help to put on 4 independent panels, 3 of which are in commercial leasing and 1 of which deals specifically with the effect of the pandemic on women lawyers, which, as everyone knows, is a very popular topic right now because women sadly are leaving the profession in droves again. So yes, I would encourage anyone who wants to be a part of any programming to get in touch with me if you want tips on how to become a speaker, how to pick a topic, how to organize talk, what speaking opportunities there are. I'm happy to answer any of those types of questions. I mean, our program for March is set, but we're always putting on programs.
So one of those programs, you do a podcast?
Joanne, before Joanne talks about that, Joanne, I just want to give a plug. Yeah. I've gone to your Women in Leasing Law Symposium, and I wanted to see what it was all about. And the speakers you had were such high quality, and we're not speaking down to the audience. We're really giving helpful tips, offered to speak with people after the program was over. It was really a phenomenal program, the one I went to. And I just wanted to commend you, for being able to put together such a program and continuing to do so for what you've done this 8 years or 9 years.
So in March will be our 8th annual program. And the programs have ranged from just, a single 1.5 hour MPLE to half-day programs to all-day programs. And then, like I said, this year we're partnering with the real property law section. And so this is right in everybody's backyard for all the Northern California people. It's at Sonoma. It's going to be great. The conference fee is not very expensive. But we're putting on a lot of great programming. There'll be dinners, wine tastings, networking events, cocktails. It's going to be a great program. So, and there's, besides my women in leasing, there's obviously the real property sessions more generally, and there's several wellness topics. So it's going to be a great program. I encourage everyone who can to consider attending.
Well, Michael was asking you about a podcast that I think you're starting, and so I'll shut up now and let you talk about that.
So my podcast just launched today.
Michael,
it's called the Commercial Leasing Diva Podcast. And in my little introductory, when you do these podcasts, you have to have a little introductory, like, what is this podcast about? I talk about how I became known as the Commercial Leasing Diva. And in the first series, I'm interviewing commercial real estate brokers, basically about the state of the market. And so we start off with Felipe Gomez-Kraus, who is one of the founders of Raise, which is a brokerage with a difference. Basically, they provide wraparound commercial services from identifying space needs of the tenant through identifying specific lease premises, helping with letters of intent, negotiating the lease, supervising the construction project. So they're sort of beginning to end wraparound services for tenants, mostly in the office space. And Felipe is a very engaging guy. We had a great conversation. So I talked to brokers from different markets, different industry sectors. I've talked to life sciences, retail, office, industrial, Northern California, Southern California. I just finished one with a broker in Las Vegas because I'm also licensed in Nevada. So anyway, we're dropping episodes on Wednesdays every 2 weeks. So the first one was today. So the next one will be on March 1st. So check it out.
So, Joanne, tell us the name of your podcast, so that wherever they get their podcast, how are they going to find you?
So it's called Commercial Leasing Diva. That's what it's called, Commercial Leasing Diva Podcast. Because some people have called me, sometimes meaning it as a compliment and sometimes not, a diva, because I only do commercial leasing. My practice is 100% commercial leasing.
Is that in the Apple Store? Or how
yes,
do you
it's on, it's part of the Apple Podcast. And it will be on YouTube and Spotify shortly.
Well, I wouldn't mind being called a diva. I've been called a lot worse. So anyway.
Well, as I talk about in my little intro episode, I at first it was not necessarily meant as a compliment, but I've really embraced it and run with it. And I feel like it's a big compliment. So.
And do you feel that if people want to get into leasing, is it critical or important to also get a broker's license if you're a lawyer?
No, I don't think that's necessary at all. That being said, I think there's a pretty high learning curve in commercial leasing because there are a lot of, and maybe this is true for a lot of practice areas, but in leasing in particular, it does help to know a lot about what brokers know and live and breathe. And I think it's really helpful to partner with brokers on transactions. Each party has a role, and if they partner, I think they can do a really good job representing their clients.
And one of the best ways to partner is an entity called California Association of Realtors. And if you're a broker, it's really easy. You pay the fee and you have access to all the same forms that I think 99% of the residential transactions used in California, and sources
Yeah,
of
we
law
don't use those
on
in
it.
commercial leasing.
Oh, that's true. Well, they do actually have one form for commercial.
There is a form, indeed. We don't use it.
Even I recognize that we are a minority participant in terms of creating documents in the commercial leasing world.
So one of my other things that I do, like I said, I'm a solo practitioner. My practice is 100% commercial leasing. I represent both landlords and tenants. And the other thing I'm doing is I'm launching a series of online courses on commercial leasing. So one of the things I'd recommend is if you're interested in learning about commercial leasing, there's tons of stuff from the real property law section, webinars that have already been recorded that are available. But my courses are also there to help you start getting the nuts and bolts down, because it's a lot. Commercial leasing, there's, like I said, it's a very steep learning curve. And indeed, even after doing it for 30 years, I feel like I'm constantly learning.
Well, I'm glad to hear that, Joanne, because that's what makes life worth living, to constantly be learning and to be helping clients and go through, new problems and help them solve their problems. Well, Joanne, we're just about at the end of our time for the interview. Any last, words of wisdom you have for our audience?
I would say that, and this is, shameless talk, sorry, insisting on participating. So here we go. Maggie's opinion is, the real property law section has so much to offer. And if, back when I was a baby lawyer, that seemed very intimidating to be involved at the state level. But everybody at the state level is so friendly and so informative and so helpful. And we put on such great programming that, reach out to Neil or Michael if you're interested in learning about any aspect of real property law. We probably have a subcommittee that you could get involved in. We could help you organize a webinar, figure out programming to put on. If you want programming that you don't see, let us know. So I guess that those would be my words of wisdom. You won't regret it.
Even as to participating in the state level committees and sections we have, there's a lot of crossover. Even if your practice is mostly estate planning, there are people in our real property section and on the executive committee that are primarily working, say, in trusts and estates. So it doesn't have to be that all you're doing all day long are fights over what's an easement or unlawful detainers or things like that. Anything almost everything touches upon real estate, business law. You got to have a place to do your business. So if you're interested, look into that.
All right. Well, thank you so much, Joanne. I think you're going to stay with us because I know you want to comment on the last case that we're involved in. And I was just looking, I forgot to remind everybody at the beginning that if you have a comment, please put it into the chat. And I don't have my glasses, but I see Scott Miller wrote something in. And Scott was talking about merger and about being, I'm doing the best I can to read without my glasses. Michael, maybe you can read in the chat what Scott Miller wrote.
Yeah, give me a second. Scott asked, to the extent the merger can also be a question of intent, when the easement is originally written and the person giving it does not want the merger to apply to both parcels that are later held in common, what can you do? Well, that case we read, the judge said it's about the intent of the parties. Also, one intent is it landlocked? Is it landlocked? Then it has to apply, or the property won't have any value. So it's not automatically applied. That was the law. It's not automatic. It's a question of fact. But if
I see Scott put a recommendation there at the end, he goes, you can write that the easement will spring back. So you can design your easement intentionally so that it will come back into existence, even if there is at some point a merger of title, and maybe there's unity of title. So that's an excellent suggestion. Thank you very much, Scott. I appreciate that. All right, so before we move on, anyone who wants to contact Ann Woodsum, her information is right here on the screen, jw@jleasinglaw.com. So Michael, let's talk about our next case. Oops, I went too far. Frazier versus Superior Court. It's an appellate division of an LA Superior Court case, but we like to talk about those. LA is the largest county in the state of California, and it represents a sizable number of residents of all of California. And so these appellate court cases arising out of the LA appellate division could have some meaning. So Michael, tell us about this case.
So what's important to know for people practicing in Los Angeles and other counties too, there are county laws and local state laws. They both apply. Generally, the county laws are going to trump the city laws, meaning if the county laws give more protection than the city laws, they're going to, be applicable. This is an LA County ordinance that enacted a requirement for the landlords to send copies of the 3-day notices to the county to keep track of. This is a new law, but the county, I think, didn't thoroughly think through how they wanted the law to be applied. And so when the tenant was served with an unlawful detainer action and wanted to defend it, they filed a summary judgment motion saying that the landlord didn't comply by notifying the county, that this eviction is going on, I should win. And the judge looked at it and just said, well, there are parts to the law that are enforceable where the county can require you to put certain words in the notices or give certain warnings or do certain things, but there's no penalty here. So if no one sends the notice to the county within the period of time that they ask, it's not going to be a defense. And if it was to be intended to be a defense, then they should have put it in the law. I think it's an oversight because almost every, tenant type defense, it says it can be asserted as an affirmative defense. Sometimes they say it can be asserted as a misdemeanor or some criminal act may occur as well. But that's the essence of this, is that, the local law can impose certain conditions that aren't going to violate some state laws, but this is something that was more informative, that the county the court's concluding that the county just wanted to be informed of evictions occurring, and that if the landlord didn't give that termination notice to them, no harm, no foul. Landlord can continue with the eviction.
And Michael, we see in this case, the notice was required to be delivered to the Department of Consumer and Business Affairs. On our next slide, you just give a sample of other types of local requirements. And I believe there's an LA one, but it requires the notice to be delivered to a different department. And
yeah, remember, it's county and city. They're two different issues.
Yeah. Right. So that actually goes to what I was gonna say. I just didn't get around to it yet, but thank you very much, which is in the area of unlawful detainers, in the area of evictions. Michael mentioned you've got city laws, you have county laws, there's state rent cap laws, there's state just cause eviction laws. This has become such a complicated field, maneuvering through the different jurisdictions and knowing the difference of what one jurisdiction requires versus what another jurisdiction requires, is that it's really become an area where anyone who is going through on the landlord side, going through or trying to evict a tenant, really needs to have an attorney who is familiar with the local law. And on the other point, if you're a tenant You want to have somebody who's representing you who is also aware of the local requirements, because there may be a defense that you can raise that might be applicable in Santa Monica, but is not applicable if you're in Fresno, for example, right?
Correct. And Neil, could you just go to the slide number 8? Just turn to the next slide.
Yep.
There you go. So what I put up here are some examples, and the city of Los Angeles just almost 2 weeks ago, a little less, implemented some new laws, and there's a series of laws, but part of it is similar to that county rule about providing a copy of the 3D notice to the city. And currently, the city doesn't have an electronic system. They want you to mail it someplace. I have the links there, and we can post that, maybe this page in the chat. We can copy and paste it in the chat for people. But I have a link to the actual ordinance, and the city of LA, yeah, right there. There's that, and there's the actual ordinance. You can click on it and you can show it. But what's different in the city of Los Angeles is they enacted a law that says very clearly, if you don't comply with this new subsection, that can be raised as an affirmative defense. And that was not in the county section. So it says 151.09H, that any violation of subsection G above, which has now been amended, that's an affirmative defense. The city of West Hollywood has something similar. Theirs applies to not just the 5-day notice, but also the summons and complaint. They want you to give a copy of the summons and complaint to the city. That's not a new law. That's been around for over 20 years, probably 25 years. The other wacky thing about it is West Hollywood, in the beginning, they wanted these things. And the last time I tried to send it to them, they sent it back and they said they don't want it, but go figure. Berkeley also has an even more tricky ordinance I saw, where you have to give a special notice at the beginning of the tenancy, such as in the rental agreement and with the notice of termination. And I was discussing this with Neil earlier, and that word "and" seems to mean that if you didn't give it in the beginning of the tenancy, then does that mean you're forever barred? You can never comply with it? I don't know, but I don't practice in Berkeley.
And I don't know either. I'm not a landlord tenant lawyer, and I don't live or practice in Berkeley, but we were just noticing the use of that word in this Berkeley ordinance that you brought up. And I would hope that there would be some way that owner of property, landlord or property manager would be able to overcome a deficiency at the inception of a lease or rental agreement. But do I know? No, I don't know.
Yeah. But
okay.
I think this is whoever wrote the county law, they dropped the ball, but I'm kind of glad they did, since I mostly represent landlords.
Good. All right, good. Well, let's look at our last segment here today on What's Up With Us, our last substantive segment. And it's really it's mentioning two cases: Another Planet versus Vigilant, which is a Ninth Circuit case that the Ninth Circuit certified to the California Supreme Court, saying, we would like you to decide this issue so that we know how to decide a case that's in front of us. And I also put on the screen a California case, one of the most recent ones, concerning the issue of insurance claims based upon COVID-19. And that one is Shusha versus Century National. And Joanne, I know you wanted to speak to this, so if you don't mind, why don't you give it a run for the next few minutes?
So unless people on here are Cairo has opinions too. Unless people on here are insurance experts, I just want to back up the train a little bit so people understand what the underlying insurance issue is. And the reason I deal with this is because in commercial leasing, we're following the COVID cases very closely, because a lot of them have to do with rent and the other chunk deals with insurance. So the first issue is, what's the type of coverage we're talking about? We're talking about a party's personal property insurance. And the traditional understanding of personal property insurance is, in order to have coverage, there has to be direct physical loss or damage. And the way that was traditionally defined until the COVID cases was something breaks. The thing is physically altered. So there's a fire and the computers fall off the desk and they crash on the floor and they break, right? So the question, and then there's another insurance that goes with it, which is loss of income insurance. So anything that you have personal property, so there's a fire. You can't use your premises. Obviously, things were damaged. And during the period of restoration, where you can't use premises, you get loss of income insurance. So those are the two coverages. The question in COVID is, all these, as soon as the lockdown orders came into place.
Joanne?
Well, Joanne is taking a little break. If you notice on your screen, I put the real basic arguments of what another planet is saying and what Vigilant is saying, what the insurer is saying. And it kind of goes to what Joanne was saying about what was the common understanding. And Vigilant...
Right. So the problem with these insurance policies is direct physical loss is never defined. Never defined. So we have a common understanding that I just explained. There's a fire, your computers get burned up, the landlord has to restore, you can't use your premises because of the computers falling down and breaking. Well, what about COVID? So there's two arguments under COVID. And the reason that the Ninth Circuit in another planet certified this to the Supreme Court is because the California courts have become split on the issue of whether COVID is a direct physical loss. So there's one line of cases that say there's no physical loss. You go into the restaurant, the tables are there, the chairs are there, everything's there. There's no physical loss. And so there's a series of cases starting with Inns by the Sea v. California, and anyone can email me, I can send you my notes on this. And the courts held in that and a number of other restaurant type cases, there's no physical loss of damage from COVID, therefore, no coverage. But then there's a second line of cases, and the Shusha is one of them. Because, of course, any smart lawyer, no physical damage. So what do we have to do? We have to show that COVID causes physical damage. Is there science that says this? Well, happily, in the Shusha case, the World Health Organization said, COVID adheres to, attaches to, and alters the surfaces of the property and surfaces upon which physical droplets of the COVID land and physically changes these once safe surfaces. And then they're relying on a case which is sort of become presidential for this type of issue, presidential, PRECENDITAL, Marina Pacific Hotels. And that was a case, again, these are all very recent cases, where a hotel argued that there is direct physical loss because COVID lives on surfaces and bonds to surfaces through physiochemical reactions involving cells and surface proteins, which transforms the physical condition of the property. So this line of cases it's delving deep. And in Shusha and Marina, basically those cases said, the burden is back on the plaintiff to prove this. Like the World Health Organization said it. So, but is there real science? And if you can show real science that the physical condition of the property changed, you might have an argument then that there was direct physical loss and you might be entitled to coverage. So going back to the original case, Another Planet, Be Vigilant, that's why the Ninth Circuit certified this question to the California Supreme Court. They said, Supreme Court of California, you've got to divide in your different appellate divisions. We need you to decide, which is it? So we're all going to be waiting with bated breath to see which is it.
Yeah, it ought to be interesting to see how the court decides. This morning I was looking at the court's docket, and it looks like all the information has been filed. So, whether it's going to be a matter of weeks or a matter of years, no one really knows, right? But the ball is in their court. To me, I was kind of surprised that it takes a federal court to bring this issue up to the California Supreme Court, given, as you already mentioned, Joanne, there is clearly 2 lines of cases already in the state of California. Maybe they just need this push from an outside court.
I think, Neil, the situation, and I'm not a litigator, I think the situation is these cases at the appellate level keep getting punted back to the trial because there's always questions of fact. So, the question of fact, is the World Health Organization correct? Is there real science that shows COVID causes a direct physical alteration of things, tables, whatever? So procedurally, they're not ready to appeal to the Supreme Court. That's my sense. Again, not a litigator.
Well, I was impressed with the Shusha attorneys, how they did it, because they made it really simple that, COVID droplets, how long they stay, they're physically on tables, physically on the floors, physically were ordered to stay away, physically we've been ordered to close the doors by the government. I didn't see the pleadings, but I have a feeling that this is echoed in the pleadings, and they made it really clear. And so at least the 2nd District, I think, got it right with reversing the demur. And, I don't know what's going on in that case, but like you said, once it gets remanded, sometimes these things just settle and you don't get the Supreme Court decisions. But I'm pretty sure the Supreme Court, they've been asked politely by the U.S. District Court or by the appellate court to rule on this. I'm sure we're going to get something.
So, and for those of you who have not been following this very closely, Shusha has a very good discussion of the 2 lines of cases. And I think if you read through Shusha, it will bring you up to speed quickly, and you will know what the other key cases are if you want to go back and look at those as well. So thank you, Joanne, for that summary and giving us some insight as to what is going on with these insurance cases. We have just a few minutes left, so I just want to make our closing remarks here. Here's a couple of webinars that I thought might be of interest. Up at the top of your screen. The Real Property Law section is always looking for, any attorney out there who wants to put on a webinar. You've got a vehicle that you could put a webinar on through, and that's the Real Property section. And so there's a contact. It's Marty Triano, marty@trianoburn.com. If you've got a good idea for us to put one on, or if you have a good idea for a webinar that you want to put on yourself and you need help gaining an audience for your idea. Joanne already spoke about the Real Property section retreat in conjunction with the Women in Leasing Law. So that's available there, and you could go on to the California Lawyers Association website, calawyers.org, go to the Real Property section, and you can find out about that. A lot of good programming is going to happen on really the 24th and the 25th. If you also just want to write something short, about a case that you saw or about an interesting issue, Real Property Law section has a monthly newsletter, and you can contact Kyle Yagi. There it is, Kyle@HickmanRobinsonLaw.com. Or if you want to write something longer, hey, you've got a lot of free time on your hand. You've got a fabulous issue that you want to discuss. We have our Real Property Journal. It's a law review type journal, and you can contact our new editor-in-chief, Brian Payne, brian.payne at, I think it's arcadis.com. So here's some other
Neil, about the articles, if people say they had a trial and they have a trial brief or an arbitration brief, you can copy and paste, from that, I make a nice short little article for the e-news. And when we send it out, it's also a good source for referrals because other attorneys are going to see that something about this area of law, and they may just, want to refer a case to you or have you involved to help their client with the case. And that's an easy way to get a little article out.
You know what, Michael, at the next Real Property Journal, I have an article coming out, but last year I wrote a short piece on a case for the e-news that you were just talking about. And I had several people contact me to ask about that case and its applicability and whether I was available, to talk about the case. So you put out these publications, you're never really sure, are they going to strike a chord in people? And just by doing a synopsis of a case, all of a sudden I got a whole bunch of responses. So you out there in our audience, you can have that opportunity as well. And I hope you take advantage of it. You see at the bottom of the screen, I just want to remind everybody something I didn't notice until somebody in the law department of my company told me about was there's a new procedure for client trust account reporting. And so make sure if you did not notice that when you renewed, that you go back into your state bar profile, because apparently a lot of people have not complied. They're delaying the penalties until after April 3rd. We don't want anybody on What's Up With Us to get caught with any of those penalties. Here we go. We got 1 minute left. Howard Klein, I see, wrote in. Here's where you got questions for either me or Michael. Here's how you can reach us. We'll see you next month. Quickly, let's see. Howard Klein. First of all, Michael says if anyone wants, copies of those cases, or I assume those ordinances that you referenced, Michael, if they didn't copy them down earlier, they might want to do that. And Howard Klein wrote in, there may be direct physical alteration, so talking about the COVID cases, but there's something in the policy, but is there something in the policy that better defines loss? Could the alteration droplets on the furniture be easily remedied by cleaning the surface of the property? That's one of the allegations. That's one of the things that Vigilante said, which is, hey, wait, you can't throw common sense out the window. If you could just spray Lysol on a surface and wipe it, where is there the physical loss or damage, right? And so we'll see
but
how
then other cases, Neil, other cases are saying it's not that simple. There's actually, and in fact, one of the types of damages that the policyholder is asking for is, listen, this complicated cleaning rigmarole is very complicated. It's not just spraying Lysol on a tabletop. It's installing these fancy filters. It's arranging for outside dining. It's totally reconfiguring the way we do business. And so there's a debate right now. Is it as simple as spraying Lysol, or is it a lot more complicated because this physical alteration has occurred with the COVID bonding with the whatever? That's the science that people are trying to debate in these cases.
And that's what the court is going to have to balance, Joanne, right? Which is, as I say, Vigilante was making the argument, no, this is a common sense approach, but the insured is making the argument, it's not as simple as that, which is what you just said. How the Supreme Court is going to balance that out, we will find out. We'll let you know on What's Up With Us if we find out, but I suspect we're not going to find out anytime real soon. Thank you, everybody, for joining us. This is my last word. Michael and Joanna, I'll let you say your last words.
I really like the cases today. It's I like insurance cases a lot. They're fascinating.
It is very interesting, and especially to me, the role of science, or waiting for science to catch up. I mean, people made these claims. A number of claims were made on insurance on March 17, 2020. So these cases, there was no science even yet, right? So the parties are litigating, and then the science is trailing behind. So to me, that was a very interesting fact about this whole situation.
And that's why even in the with the Shusha case, I think the appellant's counsel said at oral argument that they don't have additional facts like to plead to amend the demur. They're like, we're not quite sure what. It's an evolving situation. So now a little bit different, maybe. I don't know. We'll see.
Okay.
We have the Kraken, and the Kraken's out there. I'm telling you, I know a couple of people that got bit by it.
All right, everybody. Thank you. Hopefully we'll see you in March. Bye now.